no other Latin quote to add to that. Resuming debate. The Honourable Member for Honoré Mercier. Thank you, Mr. Speaker. Mr. Speaker, in October 2012, the Minister of National Defence introduced Bill C-15, an act to amend the National Defence Act and other acts. The NDP believes this bill is a step in the right direction to standardize both the military and civilian justice systems, but it does not really address the issues of grievances and summary trials. Today, I want to address these issues. Important amendments that were brought forward and adopted at the last parliamentary session, but they were not included in Bill C-15. So, this has to do with the Chief of the Defense Staff's authority in grievances, the change to the composition of the committees, the issue of people convicted in a summary trial, and the fact that people should not carry a criminal record for these matters. There are significant reforms brought forward in this bill. The NDP supports the implementation of a renewed military justice system. Canadian Forces members are subject to very high disciplinary standards. They, as Canadian citizens, deserve similar standards in their justice system as other Canadians benefit from. Reforming the summary trial system. There's great injustice in the summary trial today. A conviction in a summary trial case leads to a criminal record. The accused cannot consult a lawyer. There is no transcript of the trial, and other measures also. This is too extreme for a rather minor offense. Issues such as insubordination, quarrels, misconduct, absence without leave, etc. This might be very important for military justice, but it does not warrant a criminal record. Bill C-15 provides an exemption for certain offenses. If the offense is minor, less than $500, this not lead to a criminal record. This is one of the positive aspects of this bill, but this bill does not go far enough. At the committee stage last year, amendments proposed by the NDP broaden the list of offenses that could be considered as being minor, so therefore not leading to a criminal record. The amendment also extends the list of points that would not lead to a criminal record. This is an important advancement for summary trials, but because this amendment was not brought forward in this version of Bill C-15, we would like it to be included. I'd now like to refer to Colonel Drapeau, a retired officer who appeared before the Standing Committee on National Defense in February 2011. He said regarding summary trials, the fact is, yes, decriminalize the summary trial process. Full stop. Eliminate discretionary power, allowing commanding officers to send someone to detention. If that must be the case, send the person to be judged before court-martial, where all three are protected. So eliminating this discretionary power, as has been done in Ireland, Australia, decriminalize the process. There is no criminal record. By acting in this way, then you resolve all issues regarding representation. Members are not stigmatized because they did not brush their beard or did they not shave this morning, or because they're showing up a little late. This would apply in Canada and abroad. If we really have to prosecute someone because of a serious offense, then do it before a court-martial. that can be held anywhere in the world. The consequence of this is the criminal record. You know, Mr. Speaker, a criminal record makes life very difficult for people once they leave the military. They have difficulty traveling, getting insurance, going to the bank for a loan, etc. There are repercussions on people that are quite significant, affecting daily life, employment, crossing the border, insurances. Yes, you can perhaps find the insurance company saying no because you had a criminal record because you didn't shave on a given day. People with a criminal record may have difficulty finding a job. Who would be more well-suited to work in a security company than a soldier, former soldier? But that's not possible if you have a criminal record. In a general sense, 2 out of 3 employers will ask or have a criminal record check done on you. In the criminal code, offenses would be assaults, extortion, harassment, kidnapping, murder, homicide, theft, robbery rather. But that is not the case here with these soldiers. This is an extreme reaction. We will be penalizing members of the Canadian forces in a much harsher way than we would other Canadians. There's a long list of crimes, corruption, and other motives, grounds that would be appropriate for warranting a criminal record, but not having a person perhaps show up late on a given day, show up late at work. The BC Civil Liberties Association, another witness, said that military officers imposing sentences in these contexts want to discourage any future offenses. They are not necessarily considering the effect of a criminal record. Yes, what do we want in the armed forces? Yes, we want to discipline our members, but I do not think that the person applying the sentence wants to penalize someone for life. They simply want to create discipline within the ranks. So this is an issue of fundamental justice and fairness. These individuals need procedural protection in this context. Colonel Drapeau also adds that he strongly recommends that this committee examine the issue of summary trials. Nothing is more important for parliamentarians than to rectify a system that has an effect on legal rights of many Canadian citizens each year. It's almost difficult to challenge cases before the courts because the summary trials cannot be appealed. Moreover, all other form of challenge is practically impossible because there is no transcript of the trial and the person cannot be represented by a lawyer. I don't know how much time I have left. 1 minute? Okay. A summary trial is the most commonly used form of trial in the military system. So, the NDP believes that Canadian Forces members are subject to extremely high disciplinary standards, and they need a comparable system to that which exists for all Canadians. A military record, a criminal record, complicates people's lives greatly. So, thank you, Mr. Speaker. We would really like to see improvements to this act, and we would really like members of the committee to be taken into consideration, members of the committee who brought forward these wonderful amendments, and that is why we have this position on this matter. Thank you.
Questions and comments? The Honourable Member for London North Centre.
Thank you, Mr. Speaker. I'd like to ask my colleague if she's aware of the changes that Bill C-15 would bring about with respect to time limits of the laying of the charges that are dealt with at the summary trial. The National Defense Act currently provides that an accused person cannot be tried by summary trial unless it commences within 1 year after the day on which the offense is alleged to have been committed. Bill C-15 would also require that the charge is laid within 6 months after the day that the service offense is alleged to have been committed, ensuring timeliness for the summary trial process. Does the member not agree that ensuring a speedy trial for a relatively minor offences ensures that less serious matters are dealt with quickly and fairly? Thank you, Mr. Speaker.
L'honorable député de Honoré-Mercier.
The Honourable Member for Honoré-Mercier. I'd like to thank my colleague for her question. That's not where the issue is. What I'm critiquing is not whether it's long or short. What I want is it to be clear. I want the person to, if someone in fact, in fact, what we're talking about here is the danger of the summary trials. We want them to be effective, not. There's the unjust aspect associated with this as well.
Questions and comments. L'honorable député de Saint-Lambert.
The Honourable Member for Saint-Lambert. Well, thank you, Mr. Speaker, and I'd like to congratulate my colleague for her remarks. Now, she mentioned the UK, New Zealand, and Australia, among others, found it worthwhile to change the summary process. And the question is now, with respect to C-15, why has the government waited so long to go back to these issues? The Honourable Member for Honoré-Mercier. Well, it's a question that we have as well, and a question that I wonder is why no one listened to the important recommendations from the experts who are experts on these issues. Now, we know that the Canadian forces need discipline because we're preparing young people to defend our countries, but we can't simply punish them in any way, shape, or form. If other countries have a process to deal with these issues in their legislative system, why don't we have something? So it's in that regard that I feel we should have an opportunity to do what the other countries have done, to move forward and to give justice to our serving members.
Questions et commentaires. Reprise du débat.